Hey, Alan Graff here. I was just part of a trial. I was pretty lucky to be part of this. It was in Nashville. I just got here, just got my license, and I ended up in a 4-day trial representing two journalists, trans journalists, who were working for an organization, a press organization called The Blade. It's a left-wing, radical left-wing press, and they tried to videotape a homeless encampment. They tried to videotape the police who showed up at 10 o'clock when that was the park curfew, and try to videotape the police breaking this encampment up. They were arrested first. The police said, there they are. There's the people who are recording. Get them first. So it's pretty obvious why the police arrested them. So what happened in the trial is the judge refused to let the jury decide the First Amendment issues. Instead, he said he was going to decide them. And he said, well, the jury can't understand it. It's too complex. I need to do the constitutional issues. But I've been doing constitutional law for 30 years, and it's not rocket science. The First Amendment is actually pretty easy to understand. The actual text of it says, Congress shall make no law abridging freedom of speech, freedom of press. And the 14th Amendment took that and also applied it to the states and cities and towns as well. So no government can make any law or enact any law or use any law to prevent free speech. Now, of course, the courts have looked at exceptions to this, and you think, well, if I'm a news gatherer, and this is who was being tried, well, I can't just break into somebody's house and walk in uninvited, break the lock, and start filming them because I'm protected by the First Amendment. So the courts have designed a balancing test. Obviously, we can't let that happen. That with the First Amendment doesn't give you unlimited access as press. But there's a balancing test between what's called governmental interests and the First Amendment. And the governmental interest has to be a compelling interest, and it has to be narrowly tailored to secure that particular interest. Well, in this case, the park curfew itself is in place because the city feels that at night, more things happen, drug dealing and so forth, and that's a reasonable reason to close the parks. But the police can't apply the law in a way that prevents the First Amendment from happening, that attacks First Amendment rights of journalists. So what they did was, the encampment was there for 4 or 5 days. They could have raided it during the day at any point, but they decided to wait till Christmas Eve to raid the camp. And they showed up at 10 or 15 minutes to 10, right before the curfew, knowing that when they did it, nobody could be around. They, first of all, could use the curfew to arrest everybody, and second, nobody could be around to watch them or videotape them. So it was all planned. And so, yes, technically, the journalists broke the curfew. So they were there after the curfew. They asked to leave. They didn't leave. So they did break the law. But again, getting back to the balancing test, this is a balancing test between the governmental interest and the First Amendment. And some courts have said, or recently the Fourth Circuit has said, you should err on behalf of the First Amendment because the state is all powerful. It can do whatever it wants. In this case, what were the journalists doing? Were they breaking into somebody's house? No. Were they using the First Amendment to commit a dastardly crime? No. They were simply there after curfew. And if the police had narrowly tailored their enforcement of the law, they could have allowed them to stay in a certain point. They could say, hey, this is a designated press area. You can videotape in a place where they could actually see what was going on. They could say, here, just stand here. That would be a balance between the First Amendment and between the compelling governmental interest of having a curfew. But instead, the police knew of these folks. They were critical of the police. They singled them out. They they arrested him first before anybody else, and when they arrested him, they said, "Those are the guys who are recording." They didn't. They wanted to do this in secret. This is a dangerous precedent. We don't want the police or the government being able to do things in secret. One of the key elements and foundations of a society is transparency. We need to know what the government's doing, especially the people who have guns and badges. So this was a wrong decision. The judge really went overboard to try to find that the police were reasonable and didn't actually arrest the journalists because they were journalists, because they knew them. The facts are pretty plain that that was the case, that the police did not want anybody recording them. And so this is an issue that should have gone to the jury. As I said, it's not rocket science. Do you balance the interests of our government, our society, against the interests of having a free and open society? And that the jury was very capable of doing that. Instead, they weren't allowed to, and we ended up losing because of that. Hope that explains it.